Hello, everybody. Today we're going to be taking a look at this Texas case argued by Doug Gladden here, who's definitely one of the top three Dougs on law Twitter. He says, on Tuesday, that's this week, I presented oral argument in the 14th Court of Appeals of Texas in Houston. The issue, barely an issue, but an issue nonetheless, is whether a trial judge in a criminal case may tell the jury that beyond a reasonable doubt can be 60%. I argued correctly that the answer is no. Harris County DA's office argued that such a comment is perfectly fine. You can watch the argument here. That is what we're going to do. Here we are.
All right, we're here on a juror versus the state of Texas. Would the appellant like to save time for rebuttal?
Yes, Your Honor, I'm going to save 5 minutes for rebuttal, and my name is Doug Gladden, and I represent the appellant, Eric Juror.
All right. We are ready for your argument when you are.
Very good. May it please the court. I took the bus down here from Dallas this morning. If the bus had gotten me 60% of the way to Houston, I'd be giving this oral argument from the Madisonville Buc-ee's. If the bus driver had told me he was 60% sure he could get me to Houston safely, I wouldn't have gotten on the bus.
Just a brilliant start. I love everything about that.
I use that example because these are the two ways that we can use percentages when we're talking about the burden of proof in a criminal case. We can talk about the quantity of proof. How far did the state's evidence go? Or we can talk about the quality of persuasion, the level of certainty. How sure are you that the defendant is guilty? So when a judge tells the jury in a criminal case that beyond a reasonable doubt can be as low as 60%, it can mean one of two things. Neither is good. It can mean you can convict if the state got 60% of the way there. Or it can mean you can convict if you're 60% sure the defendant is guilty. Due process requires more than that. The reason due process requires proof beyond a reasonable doubt in the first place is because, as the Supreme Court told us in Jackson versus Virginia, that standard impressed.
Jackson versus Virginia is the kind of seminal sufficiency of evidence case. It'll be cited in Georgia, for example. It'll be cited in almost every Supreme Court opinion in a criminal case. Even if it's not raised, a lot of times they'll just observe that the evidence is sufficient under the Jackson standard.
This is upon the jury the need to reach a subjective state of near certitude as to the guilt of the accused. And so, as the court later said in Victor versus Nebraska, due process not only requires the state to prove guilt beyond a reasonable doubt, it requires the trial court to avoid defining reasonable doubt so as to lead the jury to convict on a lesser showing than due process requires. It's that duty that Victor versus Nebraska places on the trial court that settles the preservation issue in this case. Because the Court of Criminal Appeals made clear in Proenza v. State that when a law, here due process, imposes a sua sponte duty on the trial court to refrain from acting, in this case, to not define beyond a reasonable doubt in a way that lowers the burden of proof, that creates a right that is waivable only. It's not subject to forfeiture by inaction.
Counsel, does that mean that you're conceding this falls under the second category in Marin?
Pardon, Justice?
Does this mean that you're conceding that this kind of alleged error falls under category 2 in Marin?
Absolutely, Justice Bridges. This issue is a Marin category 2 right. That's what I'm advocating for. I think that's the flaw in the state's argument. The state is arguing only preservation, and It's saying that an objection was required in this case because it's saying that the trial court's comment wasn't.
Many of you will know this, but this is so often the case. There's this clear error. I don't mean that in the legal sense. I mean, there's just obviously an error. Some kind of mistake, some kind of injustice, something was skipped, something was done incorrectly. And on appeal, the state won't even argue, oh, it's not a big deal. I mean, they often will, but really their argument will boil down to, oh, you can't complain about this. It's too late. It didn't impact anything. It wasn't this, it wasn't that. Instead of even arguing as to the merits of whether there was misconduct or whether something was done incorrectly. It's incredibly frustrating.
Fundamental error. And by that, it means the comment didn't taint the presumption of innocence. But that's the type of harm-based preservation, the harm-based fundamental error analysis that the Court of Criminal Appeals told us in Forenza not to use. The preservation question under Marin doesn't look at whether there was error. And it doesn't look at whether there was harm. The preservation question under Marin only looks at the nature of the right that was allegedly infringed.
But you still have to show harm.
No, Chief Justice Christopher, you don't have to show harm. And
I thought that was only in a category 1.
No. That's what the Court of Criminal Appeals said you can't do in Proenza. Harm has to be kept separate and distinct from preservation.
No, I understand that. Okay. Assume with me that we conclude that it's a category 2, it didn't have to be objected to. It's error. There still has to be harm. Therefore, it's reversible.
No, Chief Justice Christopher, there does not have to be harm because the Supreme Court told us in Sullivan versus Louisiana that this type of error, it doesn't have to be preserved. The court finds error. You get to the question of harm. You cannot do a harm analysis for this type of error, and so it's what the Supreme Court called structural error. That it would actually be illogical to try to do a harmless error analysis under 44.2a or 44.2b. What the Supreme Court...
Well, I understand it's not under 44, but is there a constitutional harm? There still is a harm analysis.
Well, so constitutional harm, 44.2a is modeled after Chapman versus California. And what Sullivan says is that when you're talking about the trial court defining reasonable doubt in a way that lowers the burden of proof, you now have a jury that is rendering a verdict having been told the wrong standard of proof. And what the court said in Sullivan is the evidence could be overwhelming. But the fact that the jury was given the incorrect definition means that jury did not render a verdict within the meaning of the Sixth Amendment.
I love that argument, or fact, or conclusion. It's not about whether the verdict was correct or incorrect. The issue is that there was no verdict because they never actually found beyond a reasonable doubt because they weren't told what beyond a reasonable doubt is, so that determination could never have been made. That's really clever.
And harm, the question of harm looks at what impact did this error have on the verdict. If there's no verdict, you can't do that analysis. And so the Supreme Court said that this is structural error. If the court finds error, it has to reverse. Because this so infects the structure of the criminal proceeding that, you could think hypothetically about how this harmed the jury, but at the end of the day, the issue remains that there was no jury verdict rendered within the meaning of the Sixth Amendment to be harmed in the first place. And in light of that, this has to be structural error, and structural error means you don't do what we think of as a harm analysis. So,
this is the hardest part about oral argument, is when there are a series of questions interjected, and then the questions stop, and you have to decide whether to pick up where you left off, or jump ahead to, your most important point or another point. And these are the on-the-fly decisions that really make or break oral argument. And it is good to take a second to consider these things rather than just to jump into something. So it really shows Doug's experience.
The best way this court can look at it from a...
See, he pivoted into his best argument, his best conclusion. I mean, I don't know exactly what he's going to say here, but he decided he has 3 minutes left out of the 10 minutes that he has. Is interrupted, needs to jump into something, goes with the thing he most wants to say. Because he could get interrupted again. This could be the last thing he gets to say.
The best way this court can look at it from a Texas precedential standpoint, flowing from Jackson, flowing from Victor, flowing from Sullivan v. Louisiana, flowing from Proenza, is the Dallas Court of Appeals opinion in Toison v. State, decided 2 years ago. It's a published opinion. And it lays out this very analysis for a similar type of comment. Obviously, in Toison, the court equated beyond a reasonable doubt with 50% plus 1, the preponderance, what we know of as the preponderance standard. In this case, the court equates it with 60%. Okay, what is the difference between 50% and 60%?
It's 10%. I'm a lawyer, but even I know that.
For constitutional purposes, not much.
That's also
we know
true.
60% is greater than a preponderance of the evidence, but I've shown this court in the briefing. There's no support for the idea that 60% even gets you to a concept of clear and convincing evidence. We know, thank goodness for a federal judge in Utah, we know that there's at least one federal court that says 60% is not good enough for clear and convincing evidence. And if something's not good enough for clear and convincing evidence, it's not good enough for beyond a reasonable doubt, because the Court of Criminal...
See, these are the arguments that I personally really struggle with, because he's establishing that 60% is not beyond a reasonable doubt, and he's doing it very well. Whereas I would be like, hey, guys, come on. You know it. I know it. Everybody knows it. It's not just, do we have to do this? Come on, guys. But he's being very articulate and eloquent and forceful, whereas I sound like a moron.
Appeals told us in Fuller, clear and convincing evidence is too lenient of a standard for the state in criminal cases. If that's too lenient of a standard, then the judge telling the jury 60% is okay is too lenient of a standard.
What about his gut feeling comment? Is that better or
This is one of my favorite parts.
worse than 60%?
I think it's both and neither, Justice Wilson, and that's probably the worst answer I can give you. Let me put it this way.
You may win the prize on that one.
And here's why I say that. There is a substantive difference between general thoughts, when you say gut feeling or even reasonable doubt, and assigning a percentage to the concept. The reason why I didn't raise gut feeling in the issue is because there are the cases that have found no error in a judge saying gut feeling. And I didn't feel that I could make a good faith argument against that given the state of the law. But attaching a percentage...
Other than the First Court of Appeals opinion on gut feeling, have there been other Texas cases?
I believe, Chief Justice Christopher, that there is one of the 14th Court cases didn't use the pairing gut feeling, but I think the judge said it's a feeling in your gut, which is basically the same thing. I don't know if it was Latson or one of the other cases, but I think this court has looked at that too. But there were at least 2 gut feeling cases. And of course, the problem with those cases is most, and I see them over time. Can I continue answering your questions?
Please.
If you're making a good point and you're coherent, they will let you go over time quite frequently.
Most of the cases that have looked at these types of court comments in the past, 1, have not dealt with percentages, and 2, were briefed and framed at the outset under an idea of harm-based fundamental error, which just under Proenza isn't the law. And other than Toison v. State, I don't know of another case that has framed this issue as a Marin Category 2 due process question. And so what I wanted to focus on with this court is the judge tethering beyond a reasonable doubt to a number as opposed to a concept.
Is there a difference between the judge saying it's 60% and the judge saying a juror might think it's 60%?
In this context, Chief Justice Christopher, no. And the reason why is because the judge is specifically saying in his comment that if, he says, another person's beyond a reasonable doubt is 60%, and he's saying it approvingly. And so he's saying, you think this is 60%? That's okay. And so he is saying 60% is an okay example of beyond a reasonable doubt. And that's where it really is, even framing it that way in that context, he is defining reasonable doubt in that way. When he says it can be 60% or it can be 99%, both of those, the state calls them examples. Examples are equations, right? A fruit can be a banana or a pear. That's the same thing as saying that a pear is a fruit. So if beyond a reasonable doubt can be 99% or 60%, 60% is beyond a reasonable doubt. And I'm out of time. I will reserve my time. Thank you.
I bet Doug did great on the logic games portion of the LSAT.
Thank you.
So before I show you the state's argument, I want to show you a brief preview of what they're about to argue. So this is an accurate synopsis of the state's briefing in the matter.
They've done studies, 60% of the time, it works every time.
That doesn't make sense.
Okay, so now that that's done, let's return to the briefing.
Good afternoon. May it please the court. My name is Nathan Farmer and I represent the state of Texas in this appeal. The question at the center of this case is whether a trial court creates error, whether structural, fundamental, or regular error, when it acknowledges the law, that every juror has their own definition for beyond a reasonable doubt that they must arrive at. That answer is no. Chief Justice Christopher, you just mentioned about the difference between a judge saying that beyond a reasonable doubt may be 60% versus the judge saying that a juror may arrive at 60% for their definition of beyond a reasonable doubt. I think that is a much more critical difference, especially considering Toison versus State. I know I am probably mispronouncing that, but it's the best that I got. The crucial thing in Toison, the fundamental sin that the trial court committed in that case, was equating, affirmatively imposing a 50% plus one standard upon the jury.
Well, didn't he do the same thing here? He said another person's beyond a reasonable doubt. Some might say 95, and another might say 60, but they have to prove beyond a reasonable doubt whatever that means to you. Isn't that putting a blessing? Isn't that affirmatively blessing the 60%?
I think it's affirmatively blessing what that juror, as the law requires them, to arrive at their own definition. I think it then becomes...
Well, had he simply left it at that look, the state has to prove it beyond a reasonable doubt, whatever that means to you. Had he left it at that, no problem. But it seems like he affirmatively blessed the 60% view.
I would disagree with the characterization that he affirmatively blessed it. I think that there was an affirmative blessing, but it came from defense counsel endorsing the trial court's decision, the trial court's explanation of beyond a reasonable doubt during their own voir dire. I think that gets us to to determining whether or not error occurred under Proenza. As this court knows from Proenza, we have to determine whether or not a trial court's comments benefited the state or prejudiced the defense. I think specifically addressing the prejudice the defense part, that had defense counsel truly believed that that the trial court's comments and explanation prejudiced the defense in some way, shape, or form, then he could have objected, or he could have not endorsed.
Well, that's true of any structural error. He could have objected.
I completely agree.
Whether it was, terribly prejudicial or not, but there are certain circumstances where the court says you don't have to wait, you don't have to object.
Yes, Your Honor, and given the examples from Tuazin and Trevino, which I put before this court in my supplemental
Oh, we can use examples now.
authorities letter, we see the stark differences between the two. Tuazin, absolutely. The trial court made a comment that benefited the state and prejudiced the defense. In Trevino, which deals with a similar Marin Category 2, I know I am most likely mispronouncing Marin as well, a Marin Category 2 for these kinds of explanations of beyond a reasonable doubt. We see those stark differences. This case is more akin to Trevino than it is to Tuazin.
So we keep talking about blessing, but isn't what we should really be
This
looking
was my favorite question in the entire oral argument. I think that it takes what had become kind of this abstract blessing versus no blessing thing and makes the issue very concrete and transforms it from this sort of hyper-technical thing to a more practical, realistic, pragmatic view. So I love this question that's about to be asked.
So we keep talking about blessing, but isn't what we should really be looking at is to make sure that jurors understand the level of certainty, the high level of certainty that you need when describing what beyond a reasonable doubt is, if a trial judge should be talking about any of that at all.
Can you please rephrase your question, Your Honor?
So when we talk about blessing,
Can you ask me a different question? I don't want to answer that one.
60%. Where I'm asking you, and we're talking about blessing off on it, is 60% as a comment. Do you think that sounds like the level of certainty that the Supreme Court was talking about certainty for jury verdicts in criminal cases?
I think that the Supreme Court was possibly talking about whatever is in that juror's mind. I think it's also up to the parties to elucidate and pull those definitions from the jurors. We saw that in this case during both the state's and the defense's voir dire. Both the state and defense, on their own, elucidated and got those definitions out. So that way, if a 60% juror, if there even was one on the panel, was
You're not answering the question.
found and was not put on the jury.
answering the
That
question.
sounds more like harmless error than not error.
Yes, Your Honor. So I would.
So you're admitting it's error.
After.
So you're admitting it's error in a structural error case. That's okay. Well, you just lost your case.
Pardon. I can absolutely try and find some additional authorities to see if there is a harm analysis that you undergo. I would certainly hope that you would undergo a harmlessness analysis in this case, and I think that you would see that 2 words out of the voluminous record in this case.
Well, constitutional error, which is what they're arguing it should be, we have to determine beyond a reasonable doubt that the error did not contribute to the conviction.
Yes, Your Honor.
That's a very high burden.
I completely.
And you have not briefed it.
Correct, Your Honor, I have not. I fully admit that there was a gap in my research with this case. That's why I did not mention Proenza in my brief, and I do apologize for that.
This is not going well, homie. You might want to cut your losses and ice up. This isn't going well.
However, I do believe that in the supplemental authorities that Trevino is a good guidepost for this court to take. Not only does it deal with Marin Category 2, it also addresses similar comments that the trial court made. In both Trevino and in this case, the trial court explained the burden and did not impose that definition upon the jurors. The discussion in this case was not the imposition. That's to go back to Tuazin. That was.
I think this judge's question really solved the entire case for me. Did the jurors understand? Does bringing up the 60% number put the jurors in a better position to render the verdict that they're supposed to deliver? All of this, all the other discussions are kind of semantics and hyper-technical, but just saying 60% at all is inappropriate.
The sin of the trial court. Here we don't have the imposition of that burden, the imposition of that definition upon the trial court. Rather, we have merely a discussion that was then followed up with by counsel for the state and for the defense that led to no error. Plain and simple, I do not believe that error occurred in this case. And that's given that...
Wait, didn't he just say that he admitted that there was harmless error like 30 seconds ago? I'm not going to rewatch it now, but if you guys want to go back, I think it was like 2 minutes ago, he said there was error.
Comments were not.
And so if we disagree with you, that it was more towards the imposition versus the discussion, you agree there is error, harmful error.
Can you please rephrase your question, Your Honor?
If it was more imposition, like Twazin, then it's reversed.
I would agree, yes, that the law has long held that the imposition of a definition upon...
They could have just, why didn't you just, you didn't have to waste the Court of Appeals time like this. Just file, after the appeal is filed, file your own response saying, yeah, we agree, let's just remand for further proceedings. This is a waste of time.
The jurors is error, and that...
you don't have to defend every conviction.
And there's no arguing with that, Your Honor. But I do believe that in this case that it's distinct from Twazin. That's all I have.
If you're seeking justice, why wouldn't you want a new trial? Answer that question. If you're seeking justice as a prosecutor, why would you not want a new trial after the judge says 60% is sufficient? That's the answer. I would love to have an answer to that question.
If you would like to do more briefing, we'll give you to January 5th on the harm standard, and we'll give the appellant to January 20th to reply.
And would Your Honor like to discuss the sufficiency point of error as well, or?
It's up to you.
Well, Your Honor, I do believe that the state proved this offense beyond a reasonable doubt. We've discussed in our briefings between counsel and I about Alvarado. I believe that the distinction, or the differences rather, that appellant points out with Alvarado are without much distinction between the two cases. In this case, the state proved that only one person was armed, only one person had a reason to kill, and only one person was around when the complainant was shot. That was the defendant. Only one person then later on said, I only scared him. Only one person then fled the scene, and only one person called his then girlfriend to say it's not you. The jurors are allowed to make the reasonable inferences from the evidence put before them, and they made the only reasonable inference available to them, which was that the defendant shot and killed the complainant.
But the strength of the evidence does not come into play in this constitutional issue, correct?
If you reach harm, I would say that it does, and that's why I think the state's case was so strong. I think it weighs in favor of harmlessness when comparing the great weight of the evidence to the two words in the record, 60%.
And what's your feeling about gut feeling?
My feeling about gut feeling...
They're in on gut feeling. I think Doug wasn't as convinced by the gut feeling issue, but the justices do not like that.
Feeling is that it is exactly what the jurors had to come to that. I think it shows that the trial court was not imposing a definition upon the jury. Because right before the 60%, as Justice Wilson noted, the trial court also gave the high band for beyond a reasonable doubt. That 90.
So the high number matters, but you should disregard the low one.
9% sure. The trial court was merely discussing and explaining the range of possibilities that a juror may have. Going back to what I said earlier, it is then up to the parties to determine where the individual jurors stand. That's a party responsibility. That is what state and defense are charged to do during their voir dire. We try and find the best jurors possible, so does the defense. I'm running out of things to talk about, so if there are no further questions.
Okay. Thank you.
Thank you, Your Honor.
I do appreciate his candor. I probably wouldn't have phrased it that way personally, but I appreciate it. Five minutes for rebuttal.
Does the sufficiency of the evidence weigh in a harm analysis here?
Nope.
It does, Chief Justice Christopher, if you do a 44-2A harm analysis. If you treat this as structural error, as the Supreme Court said you must in Sullivan versus Louisiana, It does not. And I think I briefed No, I did. I briefed both of those, Chief Justice Christopher, in the opening brief, kind of a belt and suspenders approach, structural error. But if you view this under 44.2a, the state cannot show this was harmless beyond a reasonable doubt, because I have to respectfully disagree with my friend on the other side. The state's evidence in this case was not strong. We may see it differently on whether it was legally sufficient, but this was not a strong case. There was evidence of motive, some evidence of opportunity. I argue no evidence of consciousness of guilt, and nothing more. That is not a strong case.
Being seen running after someone with a gun after having someone...
He was just trying to give it back to him. He's like, hey, you dropped your gun, so he's chasing after him, I assume. I don't know anything about this case.
Steal from you seems like a sufficient evidence.
It is evidence. It is what I characterized as the speculative evidence of opportunity, because he ran after him with a gun, and no one saw what happened after that. And I will remind the court that what the evidence does show is that between where we see him running and where the complainant was found, there was a fence. And so wherever he ran, the one thing that we know for sure from the evidence in this case is that he never ran to where the complainant was found.
Counsel,
Yes.
what about the statements to the girlfriend?
2 statements to the girlfriend: I scared him, and then the next day say it's not you.
Particularly the second one. That's, I think a reasonable person could hear that and say that they're trying to influence a potential witness's testimony.
I think a reasonable person could definitely speculate to that. Can they infer it to the level of proof beyond a reasonable doubt? I think not in this case, and for this reason. At the point that statement was made, the appellant had just learned that he was a suspect, which weighs against him. But that's all he knew, is that his picture and Melanie's picture were on the TV. And that statement is most naturally inferred as a statement to protect Melanie. You know, don't say it's you. Like, don't get involved in this for your own sake. Because remember, even though the state argued at trial that Eric Aguirre fled the scene, leaving the scene that day was Melanie's idea, not Eric. She testified that it was her idea. And so if she's the one choosing to leave the scene, and now we have evidence of flight for her, are we saying she's a party? And I'm not saying she's a party. There's no evidence that she's a party to anything. And that's why that cuts the other way against that evidence reaching the level of sufficiency. Justice Bridges. To get to your question you asked the state, going back to the burden of proof, is 60% an acceptable level of certainty? No. It's not. There is no context in the world where 60% is an acceptable level of certainty for what we would...
Yes, thank you. Forget the legal stuff. Just like what do words mean? Is beyond a reasonable doubt 60% just in layman's terms or in any other terms? No. Stop it. What are we doing here?
Think of as beyond a reasonable doubt. It's not even a high probability in accounting and finance. Anything that requires accuracy, anything that we care about, 60% does not get us there.
Is there anything in the timing of when this statement was made versus the instructions that came out in the charge later that arguably might change the equation?
No, and I think that actually cuts to the heart of this matter. Just like in Toison, you have this definition, equating it with 60%, and then the next thing the jury hears from the court is really no other definition. They hear you must find it beyond a reasonable doubt. And the only definition they were given was wrong. And it was wrong in a way that inured to the benefit of the state and lowered the burden of proof. That was exactly what happened in Toison, and the Dallas court framed it that way in their opinion. They said the only definition the jury got was wrong. So that's error, and that's harmful. My time is almost up. If there are no other questions, may I briefly conclude for the court? I was reminded researching in this case that the standard of proof that we use is not an empty semantic exercise. We're not just playing with words. This reflects the value that society places on individual liberty. And we have set that value in a criminal case at proof beyond a reasonable doubt. And we express that by telling jurors that they have to reach a subjective state of near certitude. 60% doesn't get us there. There's a Marin Category 2 due process right not to have that happen. This issue doesn't have to be preserved. It was error, and it was structural error, and it was harmful. So I'd ask this court to reverse the conviction. Thank you.
The case of the juror versus the state of Texas is submitted, and we are adjourned.
All right.
Well, there you have it. I thought that was a very effective argument from Doug. Yeah, I don't really have a ton to add. I think it's kind of silly that the state even wanted to contest this. But yeah, look forward to seeing the opinion from the court. And I'll try to keep an eye on it. I don't know how long it's going to be, but if I see it, I'll definitely share, at least on Twitter, if not in another subsequent video. But we shall see. Thanks for watching, and have a good one.